So we now invite Mr. Lauro to make what will be a more brief opening on behalf of the charterers.
Let me speak from here. Sorry, I moved because from that point I couldn't hear very well, and so I thank you, David, for he's a very good lawyer, and he gave a very good summary of the facts, which I share, apart from a little detail. And so you have discharged any burden from my side to give a representation of the fact. The detail is that actually the time lost was not just following the fouling after the Paranagua port, but a part of the time lost was already lost because the vessel did not perform the contractual speed, even if we apply for that about a sort of half note. So I think on the facts there is no difference of opinion between the charters and the owners. What about the law? I admired your exercise, and certainly I wouldn't like to compete in trying to construe the law in a manner that complies with the owner's position. My personal belief is that you will win the case if there was actually an agreement between the owners and the charters, at least a good part of the case. And you will lose it if this agreement happened, but perhaps only in the mind of Mr. Trifillis, who is a very great mind, so a lot of things can happen, but with all due respect. This is the case. I will not enter into detail because I think we have a very experienced tribunal, some of the best legal minds of the, I wouldn't say the London shipping community, but the international shipping community. And just limit to some questions. Do we have an obligation to maintain a certain speed throughout the charter, in the charter party? The answer is yes. Is there any exception to this obligation which may be caused by an order of the charters which is connected to the normal, to the general use of the vessel in absence of an unpredictable, exceptional event? I think, again, David, the answer, members of the tribunal, is only one. No. There is no exception to this rule. Obviously, as you said, there are contractual provisions that could shift the responsibilities of the parties. I think there is a BIMCO clause that could limit the potential of the instructions of the charters to the owners within under certain terms and conditions, which exclude ports like Paranagua, in which a high rate of fouling could happen. Unfortunately for the owners, these very well-known provisions were not negotiated and applied to this contract, to this charter. Do we have any exceptional happening? You say that 40 days is longer than 30 days. Yes, it's longer. But I think it's not too unusual that in ports of this range, which is not excluded from the charter, this happens. And we know that there was no special, when there was no block, no special circumstances that could accept this rule. You put me a question, say, you claim for off-hire under clause 15 of the charter. I don't think I have the duty to give you an answer. I think it's up to the tribunal to decide what is the legal substance of my claim. I think that this is a maintenance of a vessel, so we may well be under an off-hire provision. But if the tribunal allows this in any other possible way, perhaps they may decide that this was a minimization of the damages of a party, the owners, who were in partial breach of the charter because the vessel was underperforming. So I would not like to take the, I think this is a very smart trap that you make for me, but I don't think I have the duty to qualify my claim. This is arbitration. The party has a claim. We can clarify as off-hire, as damages, as minimization of damages which caused lesser damage. There are many ways. I leave this task to the tribunal. Anything else? So I think the core of this arbitration is listening to the witnesses, and you know, I would like to hear from the parties what happened in this conversation, and there really was an agreement. Obviously, if there was an agreement, I wonder what could have been the advantage for the charters to reach such an agreement. I think this time the burden of evidence in this case is entirely in the owner's field, and since it doesn't appear to have been anything put in the record after this conversation and alleged agreement in derogation or in of a charter in writing, I think you will have explained to the charters, but first of all to the tribunal, why this was the case. So I stop here. I don't think I have much to add, and obviously I make my congratulations to the owner's lawyers for his very good presentation of the case.
Thank you, Mr. Lauro.